Georgia. And you'll recall that when we broke up yesterday, the delegation was close to finishing its responses to our first round of questions on issues 1 to 14. So to permit them to do that and then to go to the phase of follow-up questions, I'm going to hand the floor over immediately to the delegation, and I specifically give it to its distinguished head. You have the floor, ma'am.
Good morning. We have from yesterday 3 small but very important questions. Let me answer first 2 ones, questions coming from Mr. Benachour in French with your permission, and then I'll hand the third part of the question to the prosecutor's office about different individual cases. Monsieur, votre question sur l'accord procédural.
The question with regard to procedural court and the possibility of concluding procedural issues with regard to alleged torture. This is a very relevant point that we have reflected upon. Plea bargaining, as you know, was introduced into the Georgian legal system in 2004, and since that time, this is still the case, the Penal Code provides under Article 218 for a prohibition of torture and ill treatment, and that allows for exceptional plea bargaining. What does this entail? It is a plea bargain that may be concluded between the prosecutor and the suspect if this individual is particularly cooperative with the investigative authorities. This may mean, for example, that if the accused enables the prosecutor to infiltrate a network of criminal activity and prevent any particularly serious crimes, including transnational crime. In such cases, the prosecutor may conclude an exceptional plea bargain with the accused, which may lead to a guilty plea without that person being convicted and sentenced. This means that the accused will not be sentenced, and I have not used the words accused by accident. You might have noticed that in practice the exceptional plea bargain, though this may not be applied in cases of ill treatment and torture, it is possible for this to take place vis-à-vis the accused person. This is what is provided for the exceptional plea bargaining. Even in the event of cooperation, it is not possible for the defendant to engage in plea bargaining. I dare say the members of parliament will correct me if I'm wrong here, but this amendment to the legislation with a distinction between the accused and the defendant was debated in 2 sittings in Parliament, and once this comes into force, the prosecutor, even in the event of exemplary behaviour, it will not be possible for the accused or defendant to enjoy a plea bargain arrangement. If I have understood correctly from what the Ombudsman of Georgia has said, the intention is to impose a blanket ban on bargaining with the defendant or the accused person in any alleged cases of torture or ill treatment. This is something that we have not yet reflected on, and to be honest, it is not planned, and I will tell you why. If we prevent investigators and, above all, the prosecutor's office from leaving open a glimmer of possibility for the suspect to see their potential sentence being reduced, then we find ourselves in a situation of omerta, which may arise notably within a prison environment. And if the person decides to come clean and explain what has happened, then the prosecutor's office does need to have an instrument available to be able to get further into what has been happening within the prison environment and possibly get to the nub of the issue. Now, the exceptional plea bargain exists. It is not possible for the accused person, the defendant, and an absolute blanket ban on this is not something which we are considering, even though the Ombudsman has recommended this, because the prosecutor has the obligation to find the perpetrators by whatever means. The second, smaller but very important question relates to the establishment of an institution set up to investigate crimes committed by police officers or other law enforcement officials. This is a challenge for us. It's an issue, and I don't know if at the end of this session that we'll have some time left over to provide you a summary of our plans for the future in this area. But it's one of our human rights challenges. It's one which we have begun to consider in recent months. I dare say you imagine, you're familiar with the fact that in Georgia, as is seen in the last periodic report, there is a committee to combat torture. This is answerable to the Ministry of Justice, but it's an interministerial body, given that a single ministry could not address this on its own. We need all ministries on board and involved, and for that reason we set up a few years ago this interministerial committee that is currently chaired by me. At our last meeting we set up a task force bringing in the Ministry of Justice, the Minister of the Interior, the Prosecutor's Office, the Prisons Ministry, to address the issue of the establishment of such an oversight institution. I have to say that this is not an easy task because we have our own entrenched practices, we have a legal framework, and if we do take decisions, we're going to have to change laws, mentalities, practices, but it is something that we have begun in earnest to think about. Mr. Amabert from the European Union has been providing input over the last 18 months on this issue, and we do stand ready to continue considering these issues until we've come up with an appropriate solution. These issues are therefore very much on the agenda. I would now like to ask the public prosecutor to talk about the Tavtorkashvili and Mika Hadzi cases, please.
Thank you. With regard to the fact of 26 May 2011, former Minister of Interior Ivan Merabishvili was found guilty under the Article 333 of Criminal Code of Georgia. He was sentenced to imprisonment for the period of 4 years and 6 months. Also, he was deprived of holding official position for the period of 1 year, 1 month and 15 days. The case is currently reviewed by the Court of Appeal. Concerning other officials being involved in violation of the rights to assembly, the investigative department of Prosecutor's Office is conducting investigation to identify the persons. The complexity and the volume of the case and the fact of wearing masks by the law enforcement taking part in dispersal of the demonstration are the main causes hampering the process of identification of the persons involved in the criminal activities. Additionally, it should be mentioned that investigation into the fact of death of 2 persons, which happened on 26 May 2011, is underway at the prosecutor's office. Concerning this case, it can be said that the investigation is at an important stage. It is ascertained that the circumstances of the deaths have not initially been correctly shown. Additionally, investigation is also conducted on the fact of exceeding powers by police, which resulted in ill treatment, beating and arrest of Nika Samkharadze. Investigative actions are conducted to verify identities of the police officers named by the victim. As for the case of Mamuka Mikautadze, having considered the recommendation of the public defender, the case is under the investigation conducted by the Chief Prosecutor's Office. Prosecutor's Office is making efforts to ascertain the real cause of death. To this end, a number of investigative actions have been conducted. Family members, relatives, and colleagues of Mamuka Mikautadze have been interrogated. Prosecutor's Office is cooperating with family members of Mamuka Mikautadze. Versions stated by them are checked through investigative actions. For this particular purpose, at this stage, intelligence activities are conducted. Making the specific conclusions will be possible upon completion of the actions. As for the death of Shalva Tatukhashvili, taking into account the volume of the case, we will draw your attention to a number of details. Shalva Tatukhashvili was a witness for the prosecution on the case of Data Akhalaia. Considering that he gave incriminating testimony, special measures of protection have been applied with respect to him. Up to now, all the possible investigative actions have been conducted. In particular, all the persons who had relationship with Tatukhashvili prior to his death have been interrogated. The records of surveillance cameras depicting movement of Shalva Tatukhashvili have been seized. The records shown that when disappeared, Shalva Tatukhashvili was in training centers. Additionally, video cameras installed at the prosecutor's office have also been seized. The records show how freely Shalva Tatukhashvili summoned for the testimony is moving at the prosecutor's office together with his lawyers and later leaving the building again with his lawyers and heading towards Joania Square. At this stage, according to the existing evidence, the fact of committing a crime by officials cannot be ascertained. In addition, the cause of the death has been determined, namely the examination report shows that the death was caused not by ill treatment but by respiratory failure caused by alcohol intoxication occurred while being on psychotropic substances. It should be noted that the General Inspection of Chief Prosecutor's Office also conducted official inspection during which Shalva Tatukhashvili was interviewed. During the interview, Shalva Tatukhashvili stated that he was not exposed to any kind of physical or psychological duress, violence, threats, and he made this statement voluntarily. Thank you.
Thank you. I would ask Ms. Tina Khidashvili to add something.
Thank you. Just a couple of sentences to make it clear. In both cases of Mikautadze and Tatukhashvili, it was already said, but just to outline, none of the deaths happened under the custody. In first case, we had a suicide and clear suicide, and on the other, in another case, the investigation still needs to prove. But what is important to know is why Mr. Tatukhashvili was interrogated at all. He was questioned on one of those cases that Georgia was criticized over the years, and it is in your list of issues here as well. that in previous years we had several deaths on the streets by the excessive use of force by the police, and Georgian government was always requested to independently investigate those cases and bring perpetrators to justice. Mr. Tavtukhashvili was interrogated on one of those cases of death of 3 young kids in 2006, I guess, in the center of the capital city, when he was leading the operation. During the interrogation, he gave very important evidence and testified actually as to the chain of command, how those murders were happening. This is when he left the prosecutor's office, and after that the death happened. So on the other side, there is a serious suspicion, although obviously it needs to be proven and the investigation needs to go to the end, that he was murdered in order to get rid of a very important witness who was ready to give all the evidences and all the proofs to the prosecution and investigation about the chain of command over the years when those crimes were committed in different cities of the country by the excessive use of force by the police in Georgia. At that time, he was leading one of those squad teams of the police special forces over the years, and this is how he was leader of the operation, which caused 3 deaths in 2006. Thank you.
Thank you very much. That's it from the delegation. Thank you for those very informative responses, very responsive responses to the issues raised by colleagues. Follow-up questions from colleagues now. Mr. Zlatescu, you have the floor, sir.
Press the mic. The Georgian delegation for its in-depth explanations, and as received from some of the NGO specialists whom I talked to yesterday, I would like to advance a few questions, yes? First of all, is that first is 8 staff members of prisons were sentenced for torture recently. Is this torture? Is this an allegation and an accusation of torture taken as a proper term here, or are these just allegations of abuse of power in office? I understand that on the other hand, many officials accused or suspected of abuse in power during the previous era in relation with tortures are still free, and many of these files are still on hold. How could you explain that? I'm going to also ask a question about rehabilitation after tortures. There are tens of thousands of people in Georgia who have reported being tortured. However, in spite of the many efforts of the new government to rehabilitate, to physically rehabilitate and create centers, yes, for the rehabilitation and social reintegration of such former inmates, yes, there's still a lot to do, and I suspect there's a lack of funds, not necessarily of interest, in rehabilitating them psychologically. So could you comment on this, please, as well? Thank you very much.
Thank you, Mrs. Zlatescu. The next speaker on my list is Mr. Kalin. You have the floor, sir.
Thank you, Chair. I would like also to thank the delegation for the very detailed and good responses. I have one follow-up question regarding the revision of Article 310 of the Procedural Criminal Code regarding reopening of cases. The head of delegation mentioned that this is also applied to Article 8 cases of the European Court on Human Rights, meaning non-criminal cases. But do I understand correctly that the provision is part of the criminal code? So how can it be applied to other procedures that of a non-criminal nature? That's the first question. Second, regarding the planned amendments, would courts only be able to reopen cases if recommended by the ministry, or could they do it on their own if requested by the author of a communication that is submitted to us. Thank you.
Thank you, Mr. Kalin. Any other colleagues looking? Yes, Signor Salvioli, tiene la
Mr. Salvioli, you have the floor. Thank you, Chairman. I would like to thank the delegation very sincerely for the replies to my questions. These were quite complex, difficult questions, particularly those pertaining to the investigation of violations of human rights during the armed conflict. I do have two brief follow-up questions, and these relate to the issue concerning abortion. We were told here that the waiting period has been prolonged from 3 to 5 days, but I do not understand the reasons behind this change. The World Health Organization and other institutions recommend quite the opposite, and I would be interested to hear information on this point. The second question relates to objection on grounds of conscience on the part of health workers in hospitals. And I would like to ask the state whether, despite exercising these objections, there is a guarantee that sufficient services are provided in hospitals from staff members who are not objecting to work on grounds of conscience or faith to prevent voluntary abortion from taking place if necessary. Otherwise, I think the replies to the questions have been very full indeed. Thank you, Chair. Thank you, Mr. Salvioli, Mr. Chair. I see no further request for the floor.
In which case, I put a question now to the delegation. We can either go to the next round of questions on the rest of the issues, the list of issues from 15 to the end, and then you respond globally to the questions you've just heard and the second round, or you can reply immediately now to the questions you've just heard, whichever is your preference.
Nous n'avons pas compris la question en espagnol.
Okay. Signor Salvioli, parece que...
Mr. Salvioli, it would appear that the delegation did not fully understand the content of your question. Could you kindly repeat that?
Gracias.
Thank you, and my apologies. Yesterday, the delegation told us that the waiting period before an abortion may take place had been extended from 3 to 5 days. But this runs counter to what is recommended by the World Health Organization. And I would therefore like to know what reason led to this time frame being extended. I do not see any rationale for this. The second question related to the work of medical personnel, the objections to abortion on grounds of conscience. In other words, whether the state can guarantee, despite the fact that certain health professionals may object to abortion and refuse to carry it out, it is possible to ensure access to abortions without undue problems for women who would like to freely choose to interrupt their pregnancy and proceed with an abortion. Thank you.
Muchas gracias a usted.
Thank you, sir.
And I think the delegation has understood clearly now. Go ahead.
I think that we'll respond to these questions on the field, and we'll take other questions after for reflection. when it comes to the Article 310 of the Criminal Procedure Code, you are, of course, completely right, sir, when you say that it's a criminal procedure code. So when we receive a judgment or a decision on a friendly settlement or striking out of an application because of a unilateral declaration made by the state saying, yes, there was a violation from the Strasbourg court, we have in that article that in criminal cases, the Ministry of Justice, as an individual measure of redressing the violation, can arrange that the case goes anew before the criminal courts of general jurisdiction, and they reopen the case. That's the obligation that they have under this article. And either they take the same decision, declaring the same person guilty, but ensuring the equality of arms, ensuring the right of defense, which would not have been the case before, or they acquit the person. That's what happened in the first such case, Taktakishvili versus Georgia. We have the same kind of article in the Civil Procedure Code. If I'm not mistaken, it's 423, Article 423 of the Code of Civil Procedure of Georgia, which says the same, but for the civil cases. That's how the case of Okhroshidze went before the courts, because the Strasbourg court had an application, and when I saw it as a representative of the state before the ECHR, I detected from the beginning that there should be a violation of Article 8, and we negotiated a friendly settlement with the ECHR's help in that case. And we said that the child needed to know whose was his or her, I do not remember if it was a boy or a girl. And we finished the case by the friendly settlement, and this article of the Civil Procedure Code allowed me to go before the courts. The case was reopened, the father was found, and the child has now the father's name, and the father pays alimony. So in the civil and criminal cases, it's possible. What is it? It is not possible is that in those two articles, only the ECHR is mentioned. Now we intend to amend the legislation so that any international body giving views, recommendations, or decisions of any kind finding a violation, we are able to execute those decisions, whatever the name, whatever the body. Today it's not possible, and we had a case, if I'm not mistaken, from the Council of Human Rights of UN, where a violation was found, but we are not able to execute. That's why we need to change the law. When it comes to 8 prison directors, if I'm not mistaken, Mr. Zlatescu wants to know what's the article, 333, or it's torture. And yeah.
Thank you. As I have mentioned, totally in 2013, we prosecuted 48 employees of the penitentiary department. Among them, we are 8 directors of the prison and 8 deputies. Majority of them were convicted under the Article 144.1, torture, or 144.3, inhuman in degrading treatment.
So no abuse of power in those cases. Torture, ill treatment. Okay, thank you. When it comes to the abortion and 5 days, as a government member, I'll answer you on what was the political will behind that, because we voted that decision at the cabinet sitting. And from the medical point of view, if my colleague from the Ministry of Correction wants to add something, he will be free to do that. In Georgia, we have been under Soviet regime 5 million Georgians. Right now, we are not more than 4 million. According to demographic data in 20 years will be just 2 million. Georgia is facing a huge demographic problem. On the other side, the state got impression from what we see in practice that women, when they are, for instance, they are not married, but they are pregnant, the first reaction is to abort. Because being pregnant outside the marriage is sometimes a problem, especially in rural areas. So my colleague from the healthcare ministry thought and proposed to the government, and we unanimously adopted it, that we would give more time for reflection to those women. Not 3, but 5 days. So this is the political background of the decision which has been just taken. Demographic, catastrophic situation right now in Georgia, which is not new. And also more protection for those women who need and who would like to keep babies, but they do abortion to avoid social pressure, or as we say in French, réprimande. 3, 4, 5 days or more, but right now it's 5 days, there is no problem with access to abortion. After 5 days of reflection, they can have free access to abortion if they do not change their decision. And if I'm not mistaken, we do not have in practice any case where the doctor would refuse to go ahead. No problem with access to abortion. We, at least women in the government of Georgia, defend very strongly the right to abortion because it's very important for women's rights. But we decided to give 2 extra days to those vulnerable women, and especially young girls who can be pregnant, who can be afraid of being a single mother without fathers, husbands, and brothers' help. So from the medical point of view, I would ask Mr. Talakvadze, Deputy Minister of Corrections.
Thank you, Madam Minister. I'd like to respond on that. The rationale behind increasing the time from 3 days to 5 days is quite clear, I think. The logic is that social and cultural environment in some cases puts a woman under pressure to apply for abortion, and in particular the selective abortion. And then, of course, this invokes stress and emotional escalation, and the woman applies to the medical personnel for abortion. And a woman in that case had 3 days to think and to go through steps which is widely acknowledged and studied in different surveys worldwide, which is the first discussion of the issue with the friends and the family, and then considering morals and beliefs of the person, and considering the costs of raising a child and consequences, considering putting the child up for adoption as well, considering both medical side effects of having an abortion and the effects of going though with the pregnancy, considering the costs of an abortion as well, and also remembering that in the end the decision is up to the person and up her own shoulders. I think that to go through these steps of thinking and decision making, 3 days, it was actually argued by professionals that 3 days were not enough to fully rethink and reapply to this decision-making process after the first visit, when doctor is obliged by the Georgian regulations to provide full information to the woman to make informed choice. That's clear. Extension of this period serves to the escalation of the emotional background and giving more opportunities to the woman to make informed decision, not under emotional escalation. When it comes to the access to the service as such, government of Georgia or professional associations have never argued to actually restrict access to the services as an effective measure to combat selective abortion or even high rates of abortion in Georgia, because we have quite an unfortunate experience early in 90s when government decided to prohibit abortion by the legislation, and Georgia has done it, and overnight number of abortions decreased considerably, and Georgia had early joy that we have combated abortion successfully, but after 5 years reproductive health surveys discovered that maternal mortality increased very much, and it happened because of underreported illegal abortions completed at homes of the same medical personnel have been engaged in that. So this is a good lesson for Georgia for never ever coming back to the thinking of restriction to the service. Of course, the debate, which is a pro-choice and pro-life, is very long-standing in the world, and our country has found perfect solution to that problem. But at least we believe that good regulative framework and good information system, also combating the social and cultural factors which contribute to the selective abortion, is a complex response to that problem. Thank you.
Thank you. And the last question about rehabilitation of victims of torture.
Okay, thank you. When it comes to the rehabilitation of the victims, I would like to list particular steps government of Georgia has made, as well as steps government of Georgia has made in cooperation with the civil society, professional NGOs, and donor community. First of all, I would like to say that 2 years ago, government increased prison healthcare budget by 100%, which is unprecedented in the history of the penitentiary system. And with that budget, and it happened along to the 60% decrease of prison population, I'd like to highlight. When it comes to the access to medical rehabilitation and psychological rehabilitation, I'll give just figures. Last 18 months, prison administration managed to complete 8,600 transfers to the civilian hospitals for specialized care, the diagnostics, the surgical interventions, and therapeutic services. And 8,600 transfers happened out of 10,000 prison population. And hundreds of prisoners received professional, adequate care with the same standard, same medical standard as other citizens do. Of course, a lot out of that number had injuries and chronic problems from the previous experience in the prison settings. We managed to hire more psychiatrists, and my colleagues from civil society in this audience can prove that. We initiated suicide and self-harm prevention program for those who suffer from PTSD and other psychiatric and psychological problems which might be a consequence of torture and ill treatment. We opened new psychiatric unit in the correctional hospital, which serves actually for better addressing of the problem and long-term rehabilitation of the victims who still reside in the penitentiary system. We opened new rehabilitation unit for those who got physical disabilities from the violent practice. And also I have to mention donor-funded programs, and in particular European Union-funded programs for two most experienced NGOs, service providers in Georgia, who've been granted with a considerable resource to provide psychosocial and medical rehabilitation for those who've been released from the prison settings. And in addition to that, I have to say with confidence that universal health care program, which provides the essential and basic medical service to the population of Georgia, fully covers the service, medical service needed for rehabilitation, treatment, medical rehabilitation of the victims. When it comes to the psychological and psychosocial rehabilitation, well, this is quite a challenging area in Georgia because of the lack of specialists who are specialized in that area, and because of this field is quite newly developed in Georgia. So we acknowledge needs to invest more in that area and to allocate more resources. Of course, we have to acknowledge that rehabilitation of torture victims usually takes years and takes huge resources. Thank you.
Thank you very much. I have to say that the response of the minister and the deputy minister to the abortion questions was probably the most informative, thoughtful, and relevant response to any difficult issue I've ever heard in this committee, and I felt a need to say that. It was very impressive. Okay, we now go on to the second round of questions. That's issues 15 to 26. If there are any follow-up questions to the answers we've just received, they should come at that when we ask at this stage now. So with that, I turn to my list of speakers. The first speaker on my list is Mr. Kalin. You have the floor, sir.
Thank you, Chair. I will address issues number 15, 19, 20, and 21. Issue number 15 regards the system of administrative detention. Unfortunately, we didn't get a reply to this issue, so let me explain what our concerns are. I'm aware of the fact that the administrative detention is limited to a maximum of 90 days. But according to our information, the Code of Administrative Offences does not contain sufficient guarantees for procedural rights. So, for instance, if I'm not mistaken, the code does not require the police to inform individuals of their rights or the reasons for arrest. It seems that counsel are not present at administrative hearings, that often time is inadequate to prepare those hearings, and that also access to evidence, to witnesses, is limited. Of course, I'm aware this is administrative detention. This is not a criminal procedure, but still certain due process rights and guarantees are necessary. Just to lock up someone, even if it's for 3 months is a serious issue if these guarantees are not in place. So I would like to hear from the delegation how it is responding to our issue number 15. Moving on to issue number 19 on the reform of the judiciary. I very much would like to thank for all the information provided, both in the report but then also in the written and oral responses to our list of issues. That's very comprehensive, and I don't need additional information there on what is planned. I do think that Georgia is really making progress in this area. However, allow me to invite you to comment on two concerns that have been brought to our attention regarding some aspects of the practice. One is the issue of very low acquittal rates. This is also an issue taken up in one of our next questions, because what about the independence of the judiciary fair trial if at the end we have acquittal rates that seem to be very much below what is common in other countries? Then second, as you know, there also have been some allegations that cases initiated against former high officials, including the former mayor of Tbilisi or the former defense minister, have been politically motivated, and then simply would invite you to comment on those allegations. And then another issue, not directly related, but it somehow fits into the issue of judicial reform. The political prisoner amnesty law passed in January 2013, where you have been criticized by the Council of Europe's Venice Commission that this political prisoner amnesty law did not comply with fundamental principles of the rule of law, legality, prohibition of arbitrariness, non-discrimination. Again, your comments would be very much appreciated. Moving on to issue number 20 on the jury system. Again, my thanks for the information that is very comprehensive, and I now have a much more clear picture on how the jury system works. In your written responses, you mention in paragraph 91 that the judge has the right to overturn a guilty verdict of the jury only if the verdict clearly contradicts with the entirety of the evidence, is groundless, and if overturning of the guilt verdict is the only possibility for implementing fair justice, and that the judge is not authorized to use this right if he simply comes to the conclusion that the evaluation of facts or the importance of certain evidence was wrong. This means that the power to review is very limited in cases of jury trials. First, I would like to know whether the grounds for overturning a verdict in a non-jury trial are the same, or whether the power of review is more limited in jury cases as compared to the normal cases. Also, I would like to have your comments on whether the government is of the opinion that this very limited review in cases of jury trials is compatible with the requirements of Article 14 of the Covenant, which of course give a right to review. This question was raised in our issue, but I didn't see an answer to that. Then turning to issue number 21, where we ask the state party to comment on the low acquittal rate and Then in the second part of that issue, take up the issue of plea bargaining. I again would like to thank for the written explanation of the plea bargaining system, and also I would like to thank for the reference in your oral presentation that you envisage legal changes. And I would be happy to hear a bit more about what exactly the legal changes are that are envisaged. It is well known to you and to us that following the October 2012 elections, there have been, I think, something like 2,000 cases of people applying to the prosecutor's office claiming that they had been subject to pressure when entering plea bargaining agreements. And I feel that this might be linked to the extremely low acquittal rate. If, as an accused person, I'm confronted with a system where it's unlikely that I will be acquitted and I'll not take my chances, but rather enter into a plea bargaining agreement, even if I'm not guilty of the crime. It also seems, but again I would like to have your comments on that, that this is also an effect of the zero tolerance drug policy. And again, I would say there are concerns, because if you combine the two, a very strict zero tolerance policy regarding drug offenders, meaning if they are picked up, regardless of the evidence, they run a very high risk of getting very substantial prison sentences and then enter, of course, into plea bargaining agreements. Some NGOs have argued that this was even used to extract money from drug offenders and their families. That, for instance, between 2008 and in 2008 and 2009, about 44 million lari were collected like that, which is an enormous amount of money. That's more than $20 million. But that, if one links that to very low amounts of money spent for treatment of drug addicts, there is some imbalance. So I do think there are real concerns about not a plea bargaining system as such. It has its advantages and its strengths. You mentioned one before, but the actual application and the actual legal provision. So to summarize 3 points, I would invite you to comment on the low acquittal rate. Second, what legal changes are envisaged to change the plea bargaining system. But then I also would like, in addition, to know how the government is planning to address the past cases, the thousands of past cases, where people have come to the prosecutor's office and claimed that they were victims of coercion. What is envisaged? Is it envisaged to set up some kind of commission to deal with these cases, some re-examination, some remedies? If you could comment on that. And I also would like to invite you in this context to explain to us the zero tolerance drug policy as it impacts on the judicial system and seems to create the problems I indicated. Thank you.
Thank you, Mr. Kalin. The next speaker on my list is Ms. Waterval. You have the floor, Ms. Waterval.
Thank you, Mr. Chair. And I would also like to thank the distinguished delegation for their replies on my issues. I'm going to address issues numbers 16, 17, and 22. Regarding issue number 16, in your written replies to the list of issues, you stated in paragraph 73 that there is a joint commission releasing inmates, and that was not the case in previous years. Can you give us the reasons that no inmates were released in previous years? What are the release criteria for the inmates? And also in paragraph 74, the methodology of the early conditional release, including the release criteria, is being reviewed. Can you give us the outcome of the review? Can you also elaborate more on the halfway houses for the non-custodial sentences, and also the impact? And we ask you for some statistics, but we haven't received any. So maybe you can provide us with some statistics on the application in practice. With regard to issue number 17, we commend the State Party on the positive developments with regard to the prison conditions. But we would have some more information on prison number 6 and number 7. We got some information that those prisons are in horrible conditions and that they are closed institutions, they have underground cells, and there is no infrastructure for the limited abled persons. They have to be assisted by the other inmates. Maybe you can comment on that. There's also concern on the large number of drug-addicted inmates. Turning to issue number 22, has the reform of the system, of the juvenile justice system, been implemented throughout the country? We would like you to elaborate on that. And also, what is the impact of this reform system? Especially the diversion and mediation program. What is the impact of that program for the juveniles? And with that, yes. Can you also give us some relevant statistics on the impact of the program on the juveniles? And with that, Mr. Chair, I thank you. And I thank the delegation for their response in advance. Thank you.
Thank you, Ms. Waterfall.
The next speaker on my list is Mr. Salvioli. You have the floor, sir.
Muchas gracias, señor presidente.
Thank you, Mr. Chairman. Once again, my thanks to the delegation for the replies they've given to the questions that I posed. Just to enable myself to be better understood, I might possibly sign up to the Georgian as a second language program that the delegation mentioned yesterday. But moving now to my second question, this relates to issue 18. I had a question with regard to alleged acts of violence against LGBT persons. The State Party replies in paragraph 81 of its reply to the list of issues, but it supplies information only with regard to the situation in terms of the penitentiary system. The question was in fact broader than that and makes reference to how the state deals with complaints about violence against lesbian, gay, bisexual and trans persons, and was seeking information about the outcomes of investigations that had been carried out. For example, following on from the anti-homophobia demonstrations of 17th of March 2012 and 2013, and the alleged assaults that took place at that time. This part of the question has not received a reply, and I'm going to ask it again at this point, therefore, and request that the state supply information in that regard. Thank you, Chairman.
Muchas gracias a usted, señor Salvioli.
Thank you, Mr. Salvioli.
My list is Mr. Fatala. Mr. Fatala, you have the floor, sir.
Thank you, Mr. Chairman, and I would like also to join my colleagues and thank the delegation of Georgia for their replies to my question I raised yesterday. I am addressing one issue today, the issue related to the issue number 23, related to IDPs. Reply to a number of elements of this question were answered partially yesterday when the delegation dealt with other relevant matter to this question. Therefore, I will briefly focus on a number of elements which were not dealt with neither yesterday nor in Georgia's written reply, namely, one, are the IPDs having access to complaint mechanism to appeal when their rights on housing are not respected? The second question, in paragraph 114 of Georgia's reply, this reply touched quickly upon the issue of IDPs having, and I quote, equal and unlimited participation in social economic relations and receipt of social and public service. I need a clarification to this general statement in light of what is stated in the committee's question requesting information on measures taken to ensure improved access to transportation, medical services, water and sanitation, land, education and employment generating activities to IDPs at new resettlement sites. I speak here about the measures, not the law, because I know that the law is general, and then here there are some details, and I know what kind of measures are taken or will be taken. Also, does Georgia pay compensation when restitution of housing, land and property left behind is not possible? Finally, in paragraph 114 of your reply, you stated that draft law on IPD from the occupied territories of Georgia has been submitted to the Parliament for consideration. Please inform the committee whether IDPs participated in the elaboration of the law. This law addresses, as stated in paragraph 114 of your reply, the promotion of the integration of IPTs while living in other part of the country and a long-term solution to their problems, definition of guarantees for their reintegration and safety and worth return to place of their permanent residence. Please explain how practically all the above mentioned could be achieved. And thank you, Mr. Chairman.
Thank you, Mr. Fatala. Le prochain orateur sur ma liste, c'est Monsieur Benachou.
The next speaker on my list is Mr. Benachou. You have the floor, sir. Thank you, Chairman. I would like to speak to issues 24 and 25 in the committee's list of issues. Issue 24 relates to freedom of religion and religious minorities. Specifically, the questions relate first and foremost to measures being taken to ensure the return of goods seized from religious groups under the former Soviet regime. I would recall that this issue was the subject of the concluding observations during the examination of the report in 2007. This is an area where the committee had sought clarification from the Georgian government at that time. Measures taken to resolve the issue of return of property confiscated from religious communities. Secondly, it seems that a preferential tax regime exists for the Georgian Orthodox Church. Thirdly, still under 24, with regard to harassment and assault against persons belonging to religious minorities, in particular Jehovah's Witnesses and members of the Islamic community, the Armenian Church, and even the Catholic Church. There have been issues of harassment, and according to information we've received, it seems that the government is being rather passive, failing to act in the light of these assaults. The government's replies are to be found in paragraphs 115 and 116 of your replies to the list of issues. Firstly, you stressed the historic role of the Apostle Autocephalous Orthodox Church of Georgia. I do, of course, appreciate this. It is not the committee's business to enter into issues of state sovereignty of this type, and it is not up to us to call into question the historical role of a particular religious group in forging the identity of the country. You also make reference to the privilege, if you will, accorded to the Orthodox Church of Georgia by the Constitution, and also the constitutional agreement in the English, so to speak, of 2002, which provides grounds for this special status enjoyed by the Georgian Orthodox Church. And with regard to harassment and violence against religious minority groups, you indicate that investigations have been carried out. Regardless of the religion, you provide figures in paragraph 116. You say that in 2013, 26 criminal investigations had been initiated with regard to crimes committed on the basis of religious intolerance. There was one case of desecration of an Orthodox church, desecration of a grave of an Armenian clergyman, and 24 cases concerning violence against Jehovah's Witnesses. These are your replies, but I would now like to move on to the comments I have to make on your replies. Firstly, I must say that we have not really received a response with regard to the return of confiscated property. And yet we have information to the effect that, we had two important incidents that have been reported. Firstly, that religious minorities have not yet managed to have their property returned, their confiscated property. This is reported in Thomas Amambez's report of September 2013. He reports that there has been no return of confiscated property. The second point of information that is in the committee's possession is that the state is, to an extent, assisting the Orthodox Church in undertaking de facto expropriation of minority religious property to the benefit of the Orthodox Church. So this is what I had to say with regard to the return of property. Secondly, I have a question with regard to the constitutional agreement that you evoke, that dating back to the 14th of October 2002. What is its legal status? It's referred to as a constitutional agreement. Why is that? Is it part of the constitution? Does it hold constitutional value? What is its legal nature? And in particular, the question I have with regard to this constitutional agreement relates to the fact that a number of sources indicate to us that the constitutional agreement is at the root of discrimination against religious minorities in Georgia. In other words, this is a constitutional agreement that is at the source of discrimination against religious communities. This discrimination takes various forms. Firstly, we are told that the budget of the Georgian state provides for transfers to the Orthodox Church, payments, and I will give you a figure by way of a basic ballpark figure. We have been told that since 2002, the state transferred a sum equivalent to $120 million from the state budget to the Orthodox Church. This is a remark. I'm not taking it as set in stone, but I would like to hear your action nonetheless. A second indicator of this discrimination is that there is inequality in terms of the financing earmarked to the upkeep of places of worship. It is the Orthodox Church that is the clear winner in terms of this budgeting for the upkeep of places of worship. Thirdly, in terms of discrimination, it would appear that the Orthodox Church enjoys tax breaks that other religious minorities do not enjoy. A further question, therefore, what outcomes have there been from the investigations that you evoke in paragraph 116? Moving on to acts of intolerance exacted against religious minorities, a number of sources indicate that there have been assaults. When I say a number of sources, I'm not talking just about NGOs. The Georgian Ombudsman's report also contains clear indications to this effect. For example, the events in Samtagskor, and the speaker apologized for his pronunciation. There is an issue of minarets in a village there. This is mentioned in Hamad Berg's report. It seems, therefore, that there is a problem, and sources that we have heard from suggest that the state is failing to act in the light of the discrimination against religious minorities. For example, the Armenian Church, I'm just looking for the document. Yes, we have a document signed by a number of representatives of church organizations reporting incidences of behavior, improper behavior, which I'm not saying goes with the blessing of the government, but at least carries a degree of passivity, failure to act on the part of the government. Issue 25 with regard to harassment and intimidation of human rights defenders, journalists and opposition members. Here there are two problems. We have the issue of opposition members and human rights defenders, and then on the other hand, journalists. Particularly the violent dispersal of peaceful demonstrations in 2007 and 2011. And the issues of journalists, I'm going to try to read out the names of these journalists because they have been mentioned by a number of sources. Gela Tivlishvili. The speaker is spelling out the name G-E-L-A. Good, fine. This was an event that took place on 20th of May 2012. alleged arbitrary detention and physical assault. There was also alleged physical assault of Mamuka Kadava and Josep Elkanashvili, and the instance in Meriti in June 2012, Karaleti in July 2012, in the course of which journalists suffered physical and verbal abuse. The reply from the government indicates that investigations have been undertaken by the Public Prosecutor's Office and the Ministry of the Interior with regard to the journalists. Journalist Jelam Tivishvili, you state that pursuant to Article 333 of the Penal Code, investigations took place and the investigation was shelved in the absence of any evidence that the assault took place. With regard to Mamuka Kadava and Josip Elkanashvili, we are told that the Public Prosecutor's Office orders an investigation and that this is undergoing, or at least it was when you drafted your replies. These are the replies you provided, and in light of that, I would like to ask about the fact that you have not provided a reply in terms of the Meriti and Karaleti instance. And that is all I have to say on these issues, Chairman. Thank you.
Merci à vous, Monsieur.
Thank you, Mr. Benachos, the Chair.
Speaker on my list is Mr. Zlatescu. Mr. Zlatescu, you have the floor, sir.
Thank you very much. On the issue of minorities, yes, in Georgia, I would like to address two main questions. One is related to the situation of Armenian and Abkhazi minorities, and then the other one is related to Roma and Moldavian groups, yes, the so-called migrants. As a multinational state, Georgia is bound to build democratic institutions and advance a multicultural civic identitarian model. Some important advances are indeed visible today in the lives of minorities. Georgia has rehabilitated road and infrastructure in regions populated by minorities, founded a Ministry for Civic Integration and a Public Administration Institute to foster political integration of minorities, and notably has ratified the Framework Convention for the Protection of National Minorities. Generally, the concern has been to stress national concord above minority protection here. The present administration, we have learned from the distinguished delegation, is achieving memorable local government reforms. The law on self-governance was adopted in 2005 and democratic elections for new towns were organized in 2006. Still, authority remains chiefly with Georgian local and Tbilisi central officials. Some minorities are somehow skeptical that the decentralization model will grant them instant influence upon political decision processes. Government representation is the particular instance where Azeris and Armenians are not enough present. So far, the minority's typical difficulty has been failure to communicate in the official language. For a long time, Georgian administrations promoted laws binding ethnics to communicate in Georgian with local bureaucrats, obtain official papers, file complaints, or be able to access services. Government contracts and professional licenses were provisional on speaking Georgian. Has any of these issues been addressed by the new government so far? What steps are being undertaken to develop and implement more effective overall minorities policy in confirmation of the Convention for Protection of Minorities, to which I think you are part of? Has Georgia's government so far developed a practice of consultation with councils Sakrebulos, yes, in towns with over 20% minorities? Have the representatives of minorities been co-opted by now in the National Council on Civic Integration and Tolerance? Is Georgia able and willing to increase subsidies and capacities for the Ministry for Civic Integration in the said directions. Language education in minority schools seems to be poor, and in the aftermath of the conflict, reports show a slight decline for the minorities' access to higher education during the last decade. Traditionally, Armenians from Georgia have shown an eagerness to affirm their own choices on educational and cultural topics. In a post-conflict era, human rights activists agree Tbilisi needs to pay more attention to minority rights, including use of second languages if it is to avoid further conflict. Has Georgia presently ratified the chapter on trans-frontier cooperation between territorial communities or authorities in the European Charter for Regional and Minority Languages? If this hasn't occurred yet, does your country have any intention to ratify this protocol? Have the joint commissions together with Azerbaijan and Armenia been formed as to develop new history textbooks for Georgian schools, including versions in the languages of minorities? Are core social science subjects alternatively disseminated today in Azeri and Armenian? Have any GSL textbooks been printed for the use of minority educators? Now the next question is on Roma and Moldovans. As we know, these are amongst the most marginalized and socially excluded ethnic communities in the country. The Roma people appeared in Georgia after the defeat of Georgia by the Russian Empire. They mostly practiced chandlery, fortune-telling, and also sold horses. Unlike the other regions of Russian Empire, in Georgia I have learned they have never became the victims of repression. According to the letter of the Georgian State Department, relying on the data of 1989, 17,044 Roma were counted in Georgia. Among them, 53 in Tbilisi, 412 in Abkhazia, 126 in the Autonomous Republic of Adjara, 251 in Kutaisi, and 32 in Rustavi. In spite of the reduced numbers in Georgia, thrilling poverty, joblessness, limited access to healthcare and instruction, segregation, ignorance of Georgian language skills and civic education matters, absence of proper documentation, including IDs and passports, are the key problems they have been reporting over the years. The level of their engagement in social life is nearly absent. Major economic or social activities include begging and insignificant trade. Access to health leaves room for better outcomes. About the right to life, from Georgian NGO reports, we find that your country does much to defend the right to life and health of Roma. However, the Roma who appear in Georgia by chance are not protected by the government. Are there any social premises where homeless Roma could find shelter, including maybe new migrants? Is medical service available for the poorer Roma? Are Roma women bound to deliver children at home without a doctor or nurse? And this might owe to their scarcity and living customs as well. Are they given the option of asking for free emergency care? About the right to liberty and security of person, I would like to ask if Roma men are ever or have ever been subjected in the last years to illegal detention. Some of them have stated indeed that after the detention of a week or two, they are released without even knowing the reason for the arrest. Is this still actual? Is this still the case in Georgian police stations? Are there recent cases where they have been incarcerated in pre-detention cells and in pre-trial isolating facilities for more than 48 hours? The socio-economic conditions for these groups may differ from extreme marginalization, as I said, cities from the east and west of Georgia, where somehow more developed communities in districts of Tbilisi have been interviewed. These wealthier communities in or around Tbilisi are engaged in small business through which they are able to support their families. In Leninkova and Kobuleti, where some of their economical problems have been solved, indeed with NGO and government support, these groups have now asserted different needs and cognitive priorities, and this is the moment to raise the stakes. participation to trade is no longer their only purpose. They also want quality education for their children, and many of them are in pursuit of professional training to find qualified employment. How is your country going to address the problems of minorities and scarcities? If there are any provisions to adjust the potential influx of new migrants from ex-Soviet space? Overall, I would like to ask the Georgian delegation if you have developed a plan to integrate your indeed scarce Roma and Moldavian minority groups. Thank you very much.
Thank you, Mr. Zlatescu. Are any other colleagues seeking the floor? I don't see any requests for the floor. The delegation has indicated to me that it's willing to go straight to its responses without benefit of a break. Have I understood? Have I understood correctly?
Yep.
So, under those circumstances, I first of all would like to congratulate the delegation for saving that much time and giving itself the opportunity to have more time to provide the information we're looking for, and thus the benefit of the information that they'll provide. So thank you for the very exemplary approach to this question. So I immediately give the floor back to the distinguished Minister of Justice to respond to the questions that they've just received. You have the floor, ma'am.
Thank you. So, first of all, I'll take a couple of questions to which I should respond myself, and will give the floor step by step to those members of the delegation who are responsible for different issues. When it comes to the administrative detention, you are completely right that right now we still have 90 days. At some time, several years ago, it used to be 60 days, but the previous government increased the time, and now we have 90 days. I cannot agree, however, that it is just an administrative detention, because not only your covenant, but also the ECHR says that it suffices to somebody to be in jail for 1 or 2 days, and it can be called administrative detention, but it is still seen as a criminal sanction or criminal type of sanction. That's why just several weeks ago, one deputy of parliament, member of the Legal Affairs Committee, and a very distinguished lawyer and human defender of Georgia, Mr. Shalva Shavgulidze, introduced an amendment to that code of administrative offenses, proposing that this period of time be reduced to 15 days. There were a request from the civil society that we bluntly abolish the administrative detention, but the Ministry of Justice, myself, and the government of Georgia, also the Ministry of Internal Affairs, we are against of abolishing the administrative detention because it's related to our plans on liberalization of drug policy and criminal policy in the drug sphere in Georgia. So why do we need administrative detention? In the transitional period, I would explain later, but at this stage, I will just say that 15 days will be a new rule once Parliament votes, and our distinguished colleagues from Parliament seem at this stage to be unanimous in the decision about changing the rule of 90 days towards 15 days rule. But it's not enough. This code of administrative offenses is a Soviet text, and the Soviet text did not know what was the principle of equality of arms. So when the policeman and the victim, or the offender, let's say so, come in the courtroom before the judge, there is no complete of equality of arms according to the current text of the Code of Administrative Offences. The amendment proposed by Mr. Shavgulidze several weeks ago as a legislative initiative not only proposes to decrease the time limit to 15 days, but also to give procedural guarantees of safeguards to the parties. The policemen and police will have, once it becomes a law, the obligation and duty to explain the reasons of arrest to the person, and also the judge will have the duty to ensure the equality of arms in the courtroom. The police's word and declaration before the judge that yes, he saw the victim, the offender, to violate such and such provision of the Administrative Offences Code will not suffice anymore, because equality of arms mean that the parties should have equal means to show that each of them is right, and then it's up to the judge to decide who is right, who is wrong. So procedural guarantees are proposed, and also decreasing the time limit. Once we come back to Georgia, within the time limit you can give us, we are ready to submit you the draft law as introduced by Mr. Shavgulidze before the Parliament. The reform of the judiciary. We continue it, and there will be several waves of reforms. After the depolitization of the High Council of Justice I mentioned yesterday, after strengthening individual judges' independence vis-à-vis outside world, but also vis-à-vis their own leadership, we are continuing to strengthen further the individual judges. First of all, Juvenile Justice Code, and I'll come later to that question in more details. Juvenile Justice Code is a draft law prepared by the Ministry of Justice with UNICEF's and European Union's help. Georgia has no such a code, and we need it. We need it because we do not have today judges who are able to deal with juvenile cases in criminal matters, and the same judges are dealing with the juvenile cases as those who deal with the adult offenders' cases. So this will be a second wave of reform proposing Juvenile Justice Code of Georgia in autumn before the Parliament. The draft is ready, as I mentioned. We are just discussing with the Venice Commission of the Council of Europe a third wave of reform of the judiciary. It's all about automatic distribution of cases to the judges, which is not the case today. When the cases are automatically distributed to the judges, it means that judges will be more independent vis-à-vis their own leadership, who today authorize such and such that judge to examine such and such case. That's why we have different categories of judges de facto within the judiciary. Those who are always examining high-profile cases, those who are always examining the most complex cases, and those poor ones who are only examining the easiest cases. So this should cease, and we need automatic distribution of cases principle within the judiciary. We need also, within the third wave of reform, new method of sending judges to missions today, and that's what was the case under the previous different governments, not only under the immediate predecessors of ours, but under the previous governments of Georgia, judges would be sent on a mission to a remote area of Georgia if they would dare to take an independent decision on an individual case. This is absurd. This is still the situation. But after the judiciary became completely independent since 2012, in practice, the leadership of the judiciary tries to balance and to fill those vacancies more in a fairer way than it used to be the case in the past. But we cannot depend on good people working in the judiciary. We cannot depend on good personalities, we need good laws. That's why we are trying to introduce a fair mechanism of sending people on mission. First of all, there should be workload, or there should be a vacancy somewhere so that a judge is sent to a mission. When there is a vacancy and necessity, the judiciary should fill the vacancy out of the reserve judges. This is a pool of judges who are not working judges, but they're in the pool of reserve, and reserve judges should go and fill temporarily the vacancy. If there is no judge in the reserve, then the judge, because the principle of inamovability, if it's the right word in English, principe d'inamovibilité, should be respected. So the judge should agree to go to mission. I would not go in further details of the third wave of reform of the judiciary. It's pending before the Venice Commission for suggestions and improvements. The Ministry of Justice will be going to Venice at the sitting in July, August, so that in autumn we can, September, it's in September because they have summer rest we do not have in Georgia as usual. In September it will be voted in Parliament. Low acquittal rate, and in this I would ask my colleague from the Supreme Court to give the current acquittal rate, because one should know that in the past, you are completely right, the acquittal rate in Georgia was 0.01%, which is catastrophic. This was one of the reasons for which we would ourselves criticize the then government, and especially my predecessor, who used to be the Minister of Justice and the General Prosecutor of the country at the same time. Today, the acquittal rate has changed, if I'm not mistaken, and I would invite the representative of the Supreme Court to comment on that.
Thank you. High acquittal rates, prisoner sentences, and lengths of the administration custody are, I would say, interlinked somehow to each other. And all of them was consequence of the strict state policy as proclaimed by the government of Georgia. And the rationale behind this strict approach was a high rate of crimes and fragile state institutions. This approach especially applied to the corruption-related crimes. For this purpose, the criminal code envisaged high sanctions and low possibility for a judge to lower them autonomously. Moreover, principle of aggravating sentences has emphasized this number. As the crime rate started to decrease gradually, the state policy has been altered and now directed to the liberalization of the criminal code. As a result, the statistical data shows that, for example, the length of administrative custody sentenced, the maximum for 2004 was at 25 days, and we as a court have not used more than 25 days during this year. And also in 2013, the maximum was 60 days, and it was only in 2 cases. The majority of the cases during these last 2 years were under the 10 days, and around 12% were less than 20 days. So as you see, during 2012 and 13, and during these 6 months of 2014, the length of administrative custody have decreased in practice. Also, acquittal rates, the dynamics of the acquittal rates are changing. For instance, in 2013, out of 30,533 persons, 70 persons were acquitted. But we shall also mention that we don't only have a acquittal rate, but we also have a partially acquitted cases and cases which were discontinued. So altogether are around around 600. So out of 30,000 cases, 600 cases I would say is something we can say it's the cases where person was not found guilty, at least. And also in 2012, we had even better results. And for example, for instance, acquitted rate was out of 10,000 cases, 120. And in 2011, we had out of 16,000 persons, we had only 56%. So as you see, the dynamics of the acquittal rate is changing gradually, and we assume that based on the politics, it will be even it will become and improve higher, get higher. Thank you.
Thank you. We'll be transferring all the statistical data about the acquittal rate to the committee in written, of course. The same as mentioned. When it comes to the jury system is something very new to Georgia because it's not part of our legal culture. It was decided to introduce it in Georgia quite recently. The legal society is quite divided when it comes to jury system in Georgia. One part of the legal society, experts, even within our own team, the ruling coalition, one part of those think that it's completely unacceptable in Georgia because it's completely strange, alien completely. The other part thinks that in a very concrete type of cases, it can be the solution. For instance, when it comes to manslaughter, when it comes to rape, when it comes to domestic violence, when it comes in general to crimes which have to do with morals, a group of lawyers think that jury system can be the best solution. The reality is that it exists. But the system has two problems, and when I mentioned today in the beginning that our delegation thought to share with you challenges of future, not only the independent investigation body, a creation of such a body is one of those, but reforming of the jury system is yet another one. Because the jury system has two problems, at least vis-à-vis the ECHR and your covenant as well, as you mentioned. First of all, when the verdict is announced, nobody in the courtroom and in the society understands why the person was declared guilty. This is how goes the jury system. But different European countries found a solution to that without abolishing the jury system. For instance, as you know, in different countries, the jurors are given a predetermined list of evidence, admissible evidence, and list of questions. And when they come out and say, we declare the person declared guilty, and the society understands at least guesses, reason for which the person was declared guilty. We do not have such a system, so on this first point, our system is incompatible with the Covenant and the ECHR Article 6. When we had the judgment from the Strasbourg Court on the Belgium case, Taxke versus Belgium, we understood that we could share the same destiny. That's why we need to reform the system, as the Belgian government did, and will, of course, share their experience and experience of other European states in order to reform the jury system. On the second point, you are completely right. There is no possibility of reviewal of the case, of the verdict, on the merits. So right now we have just one degree of jurisdiction without any possibility of reviewal on the merits of the case. This is yet a second point on which the jury system of Georgia needs to be reformed. So challenges of future, second point, jury system needs to be reformed. That's why we postpone. Today we have jury system functional and working on manslaughter cases and very reduced number of cases, but we need 2 extra years to know if we are able to extend it to all crimes. and types of crimes. So yes, there are problems and we are thinking of reforming them. Plea bargain reform, it's already done. We are not determined to abolish this system because it's a good system. It provides an instrument when it's well organized and when it ensures right procedural guarantees to the parties. It's a good system not to allow in the country overload of the courts. It allows to finish in a speedy manner petty crimes cases and to allow the defendant to not to go before the court and get a more severe sentence. What we did, I didn't know the figure of 44 million of laris gathered by my predecessor under the plea bargaining system, but now I know it. Thank you for that information. What I know is that when I was nominated on the account of the Ministry of Justice, I found 37 million. Now I do not know where those 7 millions went. I found 37 million laris gathered thanks to plea bargainings. And this was a system of liberty in exchange of money. That's why we thought that the reform was badly needed. Not abolition of the system as such, because it works in the United States, it works in a number of European countries, and even France, who is usually reluctant to such Anglo-Saxon institutions. France also introduced a plea bargaining system. So why abolition of such a system in Georgia? No, we are not for abolition, we are for reforming. The reform is also already in Parliament. It will enter into force very shortly. We proposed that this stops being a system of gathering money from our citizens, and we introduced in the law the notion of minutes of negotiations, which was in existence in the past. The prosecutor's office and the defendant could negotiate and could bargain on the sentence in a car, in a square, somewhere. Today it's forbidden, and there should be a document written black on white what are the terms on which we bargain. And once we know that, the framework of the discussion is predetermined and there is no room for arbitrariness. Once the agreement is struck, the prosecutor's office will have the duty to draft minutes, which should be signed as any minute by the lawyer of the defendant, and we made the assistance of a lawyer within the plea bargaining system mandatory. We also proposed that the judge has more powers when approving the plea bargain agreement between the parties. And we are step by step introducing in Georgia, in the judiciary, the so-called poisonous fruit principle. For instance, in this concrete case of plea bargaining, we put in the law that when the judge verifies if the plea bargain was not struck following an ill treatment, following a psychological pressure or violence, if the defendant says that there were some pressure exerted on him or her, the judge should return the case to the prosecutor's office and should not approve the plea bargain agreement. But, and there we shared the civil society's recommendation, and the judge is obliged, when it disapproves the plea bargain agreement, in such a case when there is a doubt about ill treatment or psychological violence, not to the same prosecutor, but to a senior prosecutor who has other prosecutors under control. So hierarchy should be higher than it used to be initially. This reform is now already ready to enter into force. and it allows us to finish with the system of bargaining freedom against money. Drug policy. We need the administrative detention at least for 15 days, as it's proposed in Parliament, so that we, step by step, finish with zero tolerance policy in drug sphere. The zero tolerance policy has ended in 2012 in all other cases, but in the drug policy we have many things to do. The pillar of repression in the drug policy in Georgia works very well. It's functional. Law enforcers work very hard and seriously to combat the crime. What we need now is to acknowledge that those who use drugs without being dealers need special medical care. They need a special care from state, and on this we are working with, as I call them, with Big Five: Education Ministry, Ministry of Justice, Ministry of Interior, Ministry of Correction, and of course, first of all, Ministry of Health. We have elaborated a package of legislative amendments where we'll be hitting maybe more severely, and as we do today, those who import and export. We'll be proposing in that draft new amounts. For instance, many European countries do not have, but we borrowed from some of them the notion of commercial amount, so that somebody who is not under the influence but has quite a big amount of drug in the car or in the pocket cannot claim that he or she is a simple drug user. Commercial amount and more severe approach, why not, against those who spoil our new generations. But those who are victims, they need special care, and on this, in the prison system, but in the civilian system as well. I would ask my colleague from the Ministry of Corrections to give more clarification. What's already done within the penitentiary, because the penitentiary system for drug users is better today in Georgia than in the civilian sector, and what we planning to do in the civilian sector as well, please.
Thank you, Madam Minister. I'd like to add certain information to your report. First of all, I'd like to say about the legislative package, which actually implies changes in 5 directions. The first is the penalization of sanctions on consumption and possession of small amounts for the personal use. The second is making clear distinction between possession and illicit trade, as Minister mentioned. And third is amending list of narcotics and amounts according to the UN and European standards to define small, considerable, big, extra big, and commercial amounts for each and every psychoactive substance, and to provide full legal support and ground for harm reduction services. I'm holding a pen from Harm Reduction Network here, and I really am very well informed of 4-pillar policy, and we acknowledge the need of developing 3 other pillars. And a 5th direction would be expanding services in the penitentiary system. What we've already done is that we provided and expanded access to the specialized care for those prisoners who've been addicted on psychoactive substances. We last year transferred 10th of prisoners to the civilian drug addiction units, and we've opened our own drug unit a month ago. Also, government of Georgia made the first submission and statement this year, 2 months ago, before the country coordination mechanism for HIV and tuberculosis response for Global Fund, that from 2015 substitution therapy and harm reduction services will be expanded and available for prisoners. Even nowadays, we have 2 units in the system which provides opiate substitution treatment for those who have withdrawal syndrome. And in addition to that, I would say that we expanded and now we provide universal access to the HIV services for the prisoners, and we provide universal access for hepatitis C diagnostic treatment for prisoners. Thank you.
Thank you. To add a small clarification on the administrative detention, I would ask the representative of the Ministry of the Interior, please.
Thank you very much. I would like to add a little bit about due process rights of persons detained for administrative offenses. It was mentioned that police is not obliged to inform person of their procedural rights and grounds for detention, and also right to legal counsel was mentioned. I would like to inform the committee that police is informing the detainee about their procedural rights and grounds for detention at 3 different stages. During arrest, the person is verbally informed in a manner she understands of the grounds of the detention, as well as their procedural rights. In addition to this, under the Article 245 of Code of Administrative Offenses, arrest protocol is drawn up containing a full list of procedural rights and grounds for arrest, and the detainee signs this arrest protocol acknowledging the facts within, and if the detained person refuses to sign this protocol, it is also noted within. After the person is transferred to temporary detention isolators of the Ministry of Internal Affairs, there within at the visible areas, places, for example, at cells, rooms of investigation, there are posters provided in 5 different languages listing procedural rights of the detainees of administrative charges, and also aforementioned lists of procedural rights are also distributed to the persons placed at the TDIs, and they acknowledge the receival of these receipts by signing these procedural rights. As with regards to right to legal counsel, Article 252 of the Code of Administrative Offenses includes right to legal counsel, and as it was mentioned, these procedural rights are informed to the detainees from the outset of the detention, and detainee has the right to lawyer and has right to contact his lawyer at any time during detention, and is given possibility to exercise this right. In practice, this right is ensured without hindrance. According to respective TDI regulations, there are no restrictions concerning the duration and frequency of meetings in this regard, and confidentiality of the meetings is also, of course, ensured. Thank you very much.
Thank you. Mr. Talakwadze.
I'd like to add 3 more details to the drug policy issue. First is that Georgia has not updated its drug regulations essentially since 90s, so it is the first opportunity and real attempt for us to change essential things in the drug regulation. The second, to comment on the question which comes to the collecting certain financial resources from fines and administrative charges from drug users, I would say that Ministry of Health has doubled its anti-drug budget this year and improved coverage for harm reduction services, although it remains still on the low threshold. And the third news is that last 2 years we have lowest incarceration rate for drug consumption, drug possession crimes where actually illicit sale was not identified. Of course, the policy has to be improved further.
Thank you. Before moving to other questions, I would add that the reform of the administrative detention, of course, is not only about procedural rights decreasing the time period, but also to moving step by step towards the idea of putting those people even for 5, 10 or 15 days, not in the so-called temporary detention cells within the Ministry of the Interior, but once and for all to allow those people to be within the penitentiary system. But it's one of the components of the planned reforms underway. So now I would ask Ms. Tina Khidasheli, Parliament of Georgia, on several issues. The so-called selective justice. Second, how to repair the wrongs of the past, and maybe then will be need some help from the prosecutor's office about the manner in which we are determined to deal with all those cases we received since the election in 2012 about injustice of several type. And also third, for Ms. Tina Khidasheli, the constitutional agreement that I would call in my language concordat. Question de Benachour, Monsieur Benachour.
The question from Mr. Benachour. Because as in France there is a separation of church and state, it's for that reason we adopted this document.
Thank you. Just a couple of words to the issues that were already said, again, for the statistics and practicalities. The drug users, according to the amnesty that was mentioned here, and obviously we will address this issue separately, but in this context to be mentioned, the amnesty was used or applied to all drug users in December 2012. That was kind of a start of the policy that Minister was talking here about. The drug users who were in prison at that time were amnestied by this bill. The other one about the administrative detention, it's not about, important is not just the days, how many days the people get administrative detention now for this last 2 years after the change of power, but also how many people are getting those, they are getting ending up at the administrative detention. If we used to have a practice before, especially during the mass rallies, that police would detain basically half of the demonstrators, now it's only for the extreme cases. So you will have 2, 3, maximum 4 or 5 people detained during those mass demonstrations, again out of necessity if there are very extreme cases. In all other situations, half of the detained are freed immediately, is taken away from the place where this demonstration was happening, and they never get actually the administrative detention, but they are getting fines or nothing as a result of that. So that's also important to go by the numbers of detained, not just by the days they are getting under the administrative detention. So although we don't have it, the law is not effective yet, but in practice, for the last 2 years, it was already exercised heavily. In a liberalized manner. For the question that was that constitutes probably one of the biggest challenges for the new government that Mr. Walter Kalin raised here, how we are going to deal with the complaints and problems that prosecutor's office, for example, is facing after the elections, with tens of thousands of people applying, asking for restitution or restoring the justice in their cases, complaining there was a pressure during the plea bargaining, or even worse, they've got huge sentences as a result of no crime ever committed, but as a result of political or otherwise revenge. Just to go by the numbers, since 2012, 1st of October parliamentary elections, prosecutor's office has got 52,000 complaints as those complaints say, crimes committed before against them illegally, of illegal actions against them. Out of those 52,000, in about 12,000 cases, people are demanding reinvestigation of their cases. on different bases and with different reasons, but they are demanding reinvestigation of those cases. 2090, for example, out of those 12,000 are about the torture, ill treatment, degrading treatment. 1,400 are requesting the review of their court judgments, and that's probably part of those plea bargaining cases as well. And there are several thousand requesting the return of illegally expropriated property. Altogether, we had 5,035, approximately 5,035 items, property items, given as a gift to the state in the period of 2004-2012 by those who later got different sentences or faced justice in different ways. So these are the numbers and these are the challenges the government has. What we were doing so far is that because of a huge number of the complaints, prosecutor's office was systematizing, analyzing, working on those complaints, collecting the evidence that was mentioned in those complaints. This work is actually getting to the end, and probably by the end of summer we will have a full picture of all the, in parentheses, obviously, injustices that are mentioned in those complaints, because we don't know yet whether those are substantiated or not, but according to the complaints. And then the government and prosecutor's office will be able to come up with a policy of dealing with those issues. The numbers and challenges are also in terms of the sums of restitution. If those complaints will, and once those complaints will go under the justice system fully, then those will be billions, thousands of billions actually, of Georgian lari to be compensated by the state due to injustices committed during those 10 years of the previous regime. So the challenge is huge. It's probably one of the biggest issues that the government needs to deal. We understand that we are not going to ignore, obviously, and victims need to be compensated, but at the same time we need to come up with a strict policy that will be clear, understandable, and fair to everybody, so nobody will feel excluded or ignored out of that. Part of that is probably the answer of the story, is the answer to another set of questions we've got here about the potential or fear of selective justice in Georgia when it comes to the investigation of the cases of high officials. There are two main sets of cases against the former public officials, one on violence-based crimes and the other on corruption-based crimes, financial crimes committed by them. So when it comes to Mr. Merabishvili, that was mentioned here several times, the former Minister of Interior, the charges he's facing are related to the violence that was mentioned again in this room for these 2 days several times, including the massive use of excessive force during the mass demonstrations, particularly 26th of May 2011, which ended with the dead during the after the dispersal. Several political activists and ordinary demonstrators put in under the preliminary detention, lost for 45 days. Nobody could have identified their place or find them. And after 45 days, when they were discovered, mainly with the help of international community, they were found severely tortured. Some of them lost their eyes, some of them were deaf, some of them could not walk, some of them could not talk. Different manner used in different police stations all over the country. And those are the crimes that Mr. Minister of Interior of that time is charged with. We are hearing lots of complaints from the political opposition about the targeting of the political opponents, as he at the same time served as a Secretary General of the main opposition party in Georgia. But we say that justice is the same for everybody. Everybody is equal to law. And if the court rules that those crimes have been committed under his command, then anybody who will be charged will serve its whatever sentence court will assign for them. And we don't differentiate by the political belonging of the people once the investigation starts. The other part, the other two persons that were mentioned here, Mr. Gulaba, former mayor of the capital city, and Mr. Kezerashvili, former Minister of Defense. The charges against them are of a financial matter, or corruption charges, and those are very much related to the problems that I mentioned before, the extortion of property from the businessmen and illegal transfer of money and using the black money for both political campaign of their political parties as well as their personal gains. Those are very complex cases. Obviously, the prosecutor's office and all of us are ready to talk in details about those, but I don't think that it's the place and time for going into details of those cases. But again, these cases are exactly addressing the problems that Georgia was criticized for over the years by everybody all over the world, any international organization dealing with the human rights record of my country. And lastly, from this part, here we mentioned the case of Mr. Mamuka Kardava and the attacks on the peaceful demonstrations in March, May, June 2012. In the Karaleti case, Mereti case were mentioned here. Kelam Tiblishvili, the journalist case, also from 2012. Actually, I believe that most of those cases are written either by Mrs. Minister of Justice or myself at that time, being in opposition, because we were the subject of those attacks that you were mentioning here. These stones were thrown to us in Mereti and Karaleti. Personally speaking, even two of us were present there when those stones were thrown. Yes, it is in the interest of justice to have all those cases investigated, but at the same time, being in government today, for us, is kind of a constraint in investigating those cases, because there might be a feeling that there was a revenge from our side as we were the victims of those crimes at that time. Yes, investigation is going on, but we are trying to be as careful as possible and to have everybody identified as much as possible, which is difficult. In most of the cases, they were wearing masks, and obviously there were no identifying signs on them. That is so easy to identify the perpetrators. So with those circumstances, those cases are of the utmost importance for us to be careful, to be defined, definite, and to be absolutely clear once the charges are presented, so nobody will feel that there is a revenge from our side, because again, we were the victims of those crimes. Mamuka Kardava was chief of the political campaign of our political party in one of the districts of Georgia, for example, and it's exactly the same case as mentioned before. Thank you. Yeah, so on the other subject, the constitutional agreement, in 2002 there was a constitutional agreement between the Church, Orthodox Church of Georgia and the state. Signed. It's part of the constitution. The question was about the legal force of this concordat. It has the same force as the constitution, because again, it is part of the constitution of Georgia. It is a supreme act, the same way as the constitution. I can tell you with full responsibility, being at that time one of the authors of this concordat, that there is no provision anybody in the world can cite in this concordat which is meant for discrimination of the others, or which is giving any privileges to the Orthodox Church. It just defines the two things. One, division of the state and church. In those early ages of our democracy, that was very crucial and important, especially keeping in mind the historical role of the Orthodox Church, having a clear line dividing state and church from each other. And two, it's about the non-interference of either parties in their affairs. These are two main reasons, or two main lines in the concordat, and it never talks about any other religious groups. in the country. It never discriminates anybody against. It never says any word about its privileges towards the others. That's on the one side of it. The other parts, and I believe that the other members of the delegation will talk about it even more in details, about the changes in policy of the current government towards the religious minorities and equalizing them both in financial and legal terms to the Orthodox Church of Georgia. Thank you.
Thank you. Now, since we do not have much time left, we'll be dividing our questions in such a way. So, Mr. Talakfadze, please, on the Joint Commission and those prisoners who need special care. As we know, in the past, the inmates should take care of those who were not able to walk, for instance. And with Mr. Talakfadze's leadership, a completely new hospital was opened recently within the penitentiary system, and they have a specially dedicated floor within that hospital. Second set of the questions will be for the prosecutor's office about diversion and figures of juveniles, and also about the investigation of the violence case about LGBT on the 17th of May last year. After that, I would invite the representative of the Ministry of Refugees and IDPs on the set of questions. There were several of those. And then we'll come to the questions on religious minorities, incident in Jela, and a new agency created for religions under the Prime Minister of Georgia. And this set of questions go to the Ministry of Reconciliation and Civil Equality. Please.
Thank you, Madam Minister. To Madam Waterwall, when it comes to the Joint Commission, last year, with the engagement of civil society organizations, we completely reformed the format of the commission and voting procedure and the criteria, as you mentioned. The Joint Commission is created, this is a compassionate release commission which is created between Ministry of Health and Ministry of Corrections, and it's responsible for releasing those prisoners who are chronically ill with grave health condition, also the elderly prisoners who served half of their sentence. When it comes to the criteria, there are clear criteria set, and the criteria are complementary with the ICD system, which is the International Classification of Diseases, and mainly outlines the actually terminal stages of the certain diseases, which is given in that ICD 10th edition. And usually nowadays civil society is very much engaged in the work of that commission, and professional medical associations has guaranteed right to provide second medical opinion when it comes to the release of the prisoner. I'll just provide you with the figures about the work of the commission. The commission managed to release over 104 prisoners in 2013, and 64% out of 104 were elderly, and others were actually prisoners with terminally ill, with chronic diseases, and disabled, who actually had high dependency on care and assistance. For instance, prisoners with NLP, no light perception, have been released. 6 prisoners have been released with that diagnosis. To compare the work of the Commission, in the last 4 years, the Commission failed to release any single prisoner with a terminal health condition, and this happened because of the criteria were very out of date and non-complementary with the modern diagnostic system available in the country, the first. And the second, the capacity of the Commission and decision-making process of the Commission was as poor as it failed to respond to the applications from the prison medical service toward the Commission promptly and adequately. Now it works, I would say, efficiently, and we are still discussing to update the regulations regarding this Commission with the civil society. When it comes to the early conditional release, I would say that reform was implemented in that direction as well, and figures are clear. The Commission, after the reform, managed to release, with the early conditional release, over 2,400 prisoners last year, and to compare with the previous numbers, the same Commission, parole boards, altogether managed to release over 800 prisoners during 4 years, 2008-2012. So we can say that nowadays the Commission actually is using its mandate given, but also there are certain concerns about the procedure and further improvement of criteria for early condition release, which we are considering currently and plan to revisit the criteria again. When it comes to the halfway house, this is a brand new institution for Georgian penitentiary system, and this is dedicated for those prisoners who had to be released in an year, and they are actually equipped with proper skills, education, and occupation work training, professional training before they are released and reintegrated into the society. I would like to say that impact assessment for this institution haven't been done yet because it was recently opened this year, and end of year we plan to do independent evaluation of the operation of that institution. When it comes to the prisons number 6, number 7, as you've been mentioning, first of all, I'd like to tell you that last year we closed 3 worst prisons of the Georgian penitentiary system, number 1, number 4, number 3, and those institutions have been heavily criticized by human rights monitoring bodies in the past, so we made decision to close them. And we've replaced and opened certain new institutions. When it comes to the number 6 and number 7, last year and this year we've done considerable renovations, and we complied to the minimum living standards and minimum space standard with that institutions, although I have to say that they remain high security institutions in Georgia where gang leaders and most risky and criminal profiles are accommodated nowadays. What we plan long term we are discussing to close these institutions as well, but also we have to complete 2 other projects which will replace high-risk institutions. These are one prison in the West Georgia, Laituri prison, and another prison in East Georgia, or Heavy prison. And after completion of those projects, we will most probably make decision to close number 6, number 7. And main line and mainstream of our thinking and reforms is the separation of the prisoners by risks, which haven't happened before this moment in Georgian penitentiary system, so that we are creating low risk, medium risk, high risk institutions, and the prisoners will have natural incentive to have their trajectory between these institutions and to get engaged with the individual sentence planning programs. When it comes to disabled prisoners, I would say that today we have a special living and accommodation unit in the penitentiary system where highly dependent on care and assistance are moved to. They get adapted conditions for independent living. Also, they get long-term care and assistance with the nurses and other care personnel. And I would say that this is not just physical disabilities, but this unit serves for the mental disabilities, and this unit serves for disabilities at large when it comes to the high dependence on the care and assistance. I would say that 57 places today satisfies full demand in the system, because when we handed over the system, we had over 254 disabled with high dependency on care assistance. Now we have only 23 of them in the system. When it comes to the large number of drug addicts, I've already spoken about this, and juvenile justice reform. We have stable impact of the juvenile justice reform and liberalization. I would say that we have 300 juvenile offenders 2 years ago, and now we have only 60 juvenile offenders, and this indicator remains stable during the last 2 years. Thank you very much.
Thank you. I would like to address the question about the juvenile diversion and mediation program. First of all, it should be mentioned that we are working on the improvement of this program. Prosecutor's Office is working together with the Ministry of Justice, and with the leadership of Ministry of Justice, the new mediation center has been opened recently. This diversion and mediation program was launched in 2010, 15th of November, and initially the program covered only 4 cities, but in 2012 and 2013, 25 new cities were added, and the same year program was gradually covered the entire area. Ensuring the proper treatment of juveniles is one of the priorities of the Prosecutor's Office, and Prosecutor's Office is periodically conducting the activities which are directed towards increasing the efficiency of the diversion and mediation program. I would like just to mention the specific steps that we are taking in regarding this program. The research of the effectiveness of the program is periodically conducted by the analytical unit of the Chief Prosecutor's Office. With the support of the UNICEF, it is planned to conduct a research of the diversion and mediation program and also the juvenile detention. Specialized prosecutors for the juvenile cases will be located in all the structural areas and structural units of the Prosecutor's Office, who will undergo the special trainings on juvenile justice. And the Prosecutor's Office is also working on the concept and recommendation that will serve as guidelines for the specialized prosecutors. And also we are periodically conducting the monitoring of using the coercive measures with regards to juveniles, and for several years a recommendation has been used as a guideline principle at the Prosecutor's Office, according to which the detention can be used only as a measure of the last resort. The taken measures have a positive effect on the results, because the number of juveniles has been increased in 2013 comparing to 2012, and I would like to tell you the statistics. In 2012, 20% of the juveniles who were subject to diversion were diverted, and in 2013, 51% of the juveniles subject to diversion were diverted. In 2014, I mean only the 5 years, 40% of the juveniles who were subject to diversion were diverted. Also, it should be mentioned that the recidivism rate among diverted juveniles is very low, and it means that the program is very successful, and this recidivism rate is not more than 5%. I would like just to mention about the juvenile detention. In 2012, it was 21%, and in 2013 it is 11%, and the same percent in 2014. Thank you very much.
Thank you. Just very briefly regarding the case 2007 May 2013, the Ministry of Internal Affairs the same day initiated the investigation on the fact. As a result of the prompt investigation, we identified 5 persons and prosecuted under the Article 161 of the Criminal Code of Georgia. Among the 5 persons, 2 were Orthodox priests. currently court is hearing the case, substantially is hearing the case against the 4 defendants. On the 1st of August 2030, criminal prosecution against 1 person was terminated as a pre-trial hearing. Prosecutor office appealed the decision of the court appeal stage, but unfortunately without success. Police still keeps on investigation over the said incident. Besides this case, we are we have the additional 4 cases on the violence acts against the members of NGO Identoba. It should be mentioned that those whose violence during the incident did not meet the threshold of criminal offense, we are subject to misdemeanor proceedings. We have identified 4 persons, and they were arrested under the violation administrative code of Georgia. Also, I would like to mention, apart from the events of 7th May of 2013, criminal prosecution was initiated against 3 persons for the commission of violence on the ground of victims' sexual orientation. They are already convicted by the court. Thank you.
Thank you. The representative of the Ministry for Refugees and IDPs.
Thank you. There was a set of questions related to the IDPs, and I will proceed question by question. The first one referred to the complaint mechanism, and before I start describing how it is implemented by the IDPs, I will very briefly describe the new guiding principles, a document on the allocation of the housing units, and this procedure is based on the score system, and the each and every IDP family is evaluated in terms of their housing condition, health conditions, education, etc. And these conditions are expressed in the scores, and those IDPs who have the higher score are prioritized in allocating the housing units. And at least 1 month period is given to the IDPs until they receive the housing units, and this information about who received how many scores is uploaded on the MRA website so that IDPs can see what is their score, and in case they think that additional information about their vulnerability can be submitted, they can add some additional information. And until when the final list of the beneficiaries is compiled, this information is also again uploaded on the website so that they have enough time to make complaints to the ministry about their scores and how they were evaluated and prioritized in this list of IDP beneficiaries. And the special categories of people, IDPs below the poverty line, person with disabilities, elderly people, female-headed families, etc., are also given higher scores, so they are given priority in allocating the housing units. And the applications are examined by the selection committee, and in order to ensure that there is no abuse and undue influence on the selection process, the examination of applications proceeds in the following way. There are 3 groups formed, which work independently from one another. The first group receives applications, another group studies them, and the 3rd group monitors the visits on the site to check the living condition of the applicant IDPs. And the information is gathered and is submitted to the Commission with 11 persons, and the Commission adopts the final decision of the selection of the beneficiaries. This is in terms of the complaint when it comes to the allocation of housing units. But when it comes to the quality of the housing, IDPs also have the opportunity to complain on the quality, and there is in the agreement with the construction company that either Ministry of IDPs concludes or the Ministry of Regional and Infrastructure issues, there is a 1-year period, which is the guarantee period, and the retention of 10% of the total amount of the contract amount. which means that after exhaustion of the 1 year period, during the 1 year period, IDPs have opportunity to complain on the quality, and the retention amount is given to the contracting company after 1 year period, after rectifying all the faults that the IDPs might identify in their houses. With regard to the second question on the participation in the social economic opportunities, first of all, this is the integral part of the housing programs, which means that the new approach of the ministry is to allow IDPs to live in the places, in big cities, for example, where there is better access to the livelihood and employment opportunities, and they have reached certain level of integration in terms of the education, healthcare, etc., to stay in the same place, which was not the case previously, when the IDPs sometimes had to be taken in the remote places where they had problems with the livelihoods and income generation opportunities. And also, alternatively, the houses are also can be made available in the urban areas, in the rural areas, for those IDPs who have some agricultural background and prefer to live in the rural areas, where individual houses are also provided with the land plots where they can grow some crops. And what is most important, we have developed the livelihood state strategy and action plan, which means that, which defines that IDPs will be provided with certain interventions, like support to their agricultural activities, increased access to the financial resources and micro grants, vocational education, and access to monetary grants, livestock, etc. And so we have also developed the action plan for in that direction. In terms of the access to the health, education, employment, land, etc., in this case we try to have the interministerial approach and integrate IDPs in the strategies of other ministries. On the land issue, we are cooperating with the World Bank to identify the land that is the free land around the IDP compact settlements, and to also identify the forms of ownership into which these lands can be transferred to the IDPs. With regard to the draft law has already entered into force in March 2014, and the issue how it provides the long-term solutions is that the provisions of the law are translated into the relevant strategies. We have updated the strategy and action plan on the IDPs, and also, as I mentioned, the livelihood action plan. And these measures also in their turn are translated into the very concrete measures, like we have established the legal entity of public law, which will be implementing the livelihood projects. And in that direction, we have negotiated with the European Union to allocate 5 million euros grant this year, and next year there will be another 5 million for the livelihood projects. And with regard to the housing, as I mentioned, there was the guiding principles developed, and also what is most important, the budget for the housing was increased. Previously it was 15 million GEL, but now this year it will be 40 million, and next year we will increase it up to 50 million. And this enabled us to provide housing units to 2,100 IDP families, which amounted to 8,000 IDP individuals. And next year, until the end of this year, we anticipate to provide houses to 2,500 families, which amounts to 10,000 IDP individuals. And about half of those IDPs who have houses already, we are transferring these living spaces into the private ownership, and we are trying to speed up the process so that all of them enjoy this opportunity. And the new law envisages that they can retain these houses even after they return to their permanent places of residence. And the last question, which referred to the housing restitution, We have also made some progress in that regard, and we have been cooperated with a number of international experts. Also, we have formed a working group where the representatives of the relevant ministries are participating in the discussions, and we have drafted the action plan for housing and land property protection, which defines the key steps and activities with a concrete timeline and resources required. And the activities recommended by consultants cover 2.5-year period of time, and it's separated in 5 phases. These phases include the creation of the credible database of the housing and land property protection claims, and which could be used in a number of different ways in the future, for example, through a negotiated restitution process or in international or domestic legal proceedings. And we try to design the work plan to strike in a manner to strike a balance between the international standards, adopting an all-inclusive approach, and doing no harm, such as raising IDP expectations or political tensions. So we are in the process of still working on this action, the work plan. We expect some international expertise also to use in this direction. So I hope I exhausted all your questions. If you have other questions, please feel free. Thank you.
The representative of the Ministry of Reconciliation and Civil Equality, please.
Thank you. I'll tackle the question on the religious organizations and the restitution of property. Since 2007, Georgia has made significant progress in the sphere of restitution of property of religious organizations confiscated during the Soviet totalitarian rule. In July 2011, the Parliament of Georgia passed an amendment to the Civil Code of Georgia, adding to it a provision which grants to the religious organizations that have historic ties to Georgia or are defined as religions in the legislation of a Council of Europe member state the choice to register as a legal entity of public law. At the same time, religious organizations preserved their hitherto right to register as private, non-profit legal entity or indeed not register at all. It should be emphasized that even if registered as legal entities of public law, religious organizations enjoy total freedom from the state and do not assume the same responsibilities as other typical legal entities of public law do. Giving the status of LEPL was of crucial importance and constituted a major step forward for religious organizations, which in the past had the only option of registering as associations, foundations, or not-for-profit organizations under private law. With this new status, the religious nature of these organizations has been explicitly acknowledged, which they had been demanding for years. What is perhaps most important in terms of property restitution is that under Georgian legislation, legal entities of public law compared to private non-profit organizations are better positioned to receive property from the state and more easily do so. Under this law, a dozen organizations have already applied to the Public Registry Agency and registered as legal entities of public law. In parallel, the Ministry of Culture of Georgia has been registering and granting the status of culture monuments to the religious buildings of various unions. Back in 2009, up to 50 Armenian churches, 10 mosques, and 5 synagogues had been registered. In 2011, the status of cultural heritage monument was granted to the Armenian church and a synagogue in Batumi, Orta Jami Mosque in Batumi, Rabati district in Akhaltsikhe, including 2 ancient synagogues, Tbilisi Synagogue and a synagogue in Kutaisi were also granted a status of cultural heritage. Besides, various cultural monuments have been restored. As you are well aware, property restitution is a complex issue. The government tried to tackle this issue, and in November 2013, it set up an interagency commission with the purpose to study and recommend on, amongst other, restitution issues. The Commission addressed the government with a recommendation to partially recover the material and moral damage incurred to a number of religious unions registered as legal entities of public law, namely the Evangelic Lutheran, Islamic, Judaic, Roman Catholic, and the Armenian Apostolic Churches. The Commission concluded that these are the religious unions whose losses are factually established by numerous independent, documented sources, and their restitution causes no doubt. The Commission said it was ready to also study the cases of damage incurred to other religious unions under the Soviet totalitarian rule and further review the possibility for restitution to them as well. It is true that the Georgian state recognized the losses to the Georgian Orthodox Church during the Soviet times and concluded with it the constitutional agreement that provides state financial support. However, the above-mentioned initiative was developed exactly with a view to extending the principle of equal treatment to other religious organizations. Both of these decisions have been held by the international community and members of the Georgian civil society. The state already made the decision to allocate 5.5 million lari, which is approximately $2.5 million USD, to the 5 religious unions to be distributed proportionally. Since the exact amount of damage suffered by these organizations remains unknown, this payment is only symbolic. Okay. Well, this is only symbolic. The religious organizations, and the question was raised here about upkeeping of their places of worship, can actually use these funds for construction or restoration of their cultural heritage monuments, support for academic activities or publications, as well as for holding of clerical services, purchase of property, or the implementation of any other activities authorized by the law. Lastly, I would like to mention that the government has also established a legal entity of public law, which is called the State Agency for Religious Issues, in February 2014, and this is the agency which is charged to support the government in relations with and supporting the religious organizations. It prepares and studies the situation and prepares reports and studies the situation in the sphere of religions, prepares recommendations, drafts legal acts with respect to the challenges that religious unions face, studies best practices, and delivers recommendations to authorized agencies on the construction of religious worship places and buildings. It also elaborates proposals on education in the sphere of religion and prepares proposals for the support of tolerance among civil society, including youth. As of now, and that's my last sentence, the agency has taken over the functions of the Commission, including that of the property restitution, and hence the Commission has been abolished. I would also like to say a couple of words about the Chela village. Yes, the village in Chela, village Chela, and the mosque, which the minaret of which was removed. That was a significant and important incident. Partly the reason for this was that the legal ground was not, and the documents were not in total conformity with the law of Georgia, and there was also a loophole in the legislation. And our Minister for Reconciliation and Civil Equality promptly reacted and went, visited the village as well as in villages of other religious incidents, and consulted with the local authority, local population, and the leaders of the religious organizations. And our representative also consulted with the leader of this mosque in Chela in terms of preparing the ground and putting all the documents in order to apply for a legal and legitimate construction of the minaret, which actually was done after some time, very soon. And exactly in order to prevent similar incidents in future, the government set up this agency to make sure that there is sufficient legal grounds, and the legislation is in force, and all the loopholes are filled for construction of these buildings.
Merci.
Thank you.
Désolée. Ce qui a été
Angela, what was possibly not very clear, one day the population of the village woke up and found out that the Muslims in the village had covertly put up this minaret during the night. There was no building permit, nothing. So the competent authorities dismantled the minaret, which was then placed under seal. And then once the regulations were respected, once all the procedures had been carried out, including with the Ministry of Justice, whose responsible for the territory there and for providing the building permits. Once all the procedures have been carried out according to the law, the minaret was put up where it was supposed to be. So the minaret now has been put up, but legally. In the future, whenever there are illegal religious constructions that take place, the authorities will carry out the same procedure, because it is out of the question that the religious communities take it on themselves to decide to erect such buildings in secret. So this is all perfectly clear as far as the minaret was concerned. We also encountered the same construction problems or building problems with Orthodox buildings. We have this problem. We fight against this problem because the law should be applied equally. Now, before going on to the very last part of our statements, to the chair of the Parliamentary Committee on Human Rights, who was one of the authors of the law on amnesty, who will also symbolically close the various statements made by our delegations. Mrs. Cabacelia cannot fail to point out that Georgia is one country where there was no religious wars, no religious conflicts, where Jews, Armenians, Christians, Georgian Orthodox, Muslims have always lived side by side peacefully. Jews came into our country in BC, and we have had Jews who came to our country then, and we have since as well. They have always lived peacefully side by side. Now, it was decided that all religions, not just the Orthodox Church, should be financed by the state, and this will cover the Armenian Church, the Muslim religion, Jews, and the Catholic Church. So that's something new that happened this year that would say that it's not just one church that will be financed by the state. And now I'll ask for Madame Basile to speak about the law on amnesty for 5 minutes, I think. Thank you.
Thank you. Thank you so much. Thank you, members of committee, for your interesting questions. Human Rights and Civil Integration Committee of Georgian Parliament has the parliamentary monitoring commitment. Our committee makes contents monitoring how the human rights are protected by each ministries. After 2012, our government protection of human rights declared as a main priority. We have received human rights strategy for 7 years. Our committee has worked on the law of amnesty. By the Amnesty Act, we decreased the number of prisoners for 60% in Georgia today. And Georgia today is not on the first place by the prisoners' number in Europe. I'm happy that I am after amnesty project. In Georgia, we are political prisoners. About this fact, we are mentioned in the report of United States Department of State, in the report of Council of Europe Human Rights Commission Thomas Hammerberg. And the Parliament, we worked about these cases with the experts and Joe, and we used October 2012 resolution of Council of Europe. This was about the criteria of political prisoners. We have used this criteria. This was very principled and just decision and released political prisoners. This decision was made for protection human rights. We start in the Parliament listening the public defender report in the new form with the participation of government members, and we discuss about all important facts. We observe the fulfillment of recommendation. Representatives, the response of the Ministry of Justice and other representatives of other ministries, we are very precise and thorough. They work very hard. Government would not be self-confident about the result of human rights protection. We should always try to have more high standards. Most of us, we are defenders of human rights in past years, and today we know the human is a main, and everything should do for human and for protection of human rights. Thank you so much.
Thank you very much indeed. That message has been coming throughout our discussions in the last 2 days. I will allow one or two very, very brief, certainly not more than a minute, questions, follow-up questions from colleagues. The delegation may well not have time to respond to them orally, but of course there is the possibility of written questions. At the moment, I only have one colleague seeking the floor. Are there going to be any others? No. Mr. Shani, you have the floor and a minute.
Thank you, Mr. Chair. And at a very, very late point in the game, I would want to congratulate the delegation. I have a follow-up question on the selective justice point that was addressed by the delegation. And of course, the dilemma facing the state party is obvious here. You need to prosecute people who have allegedly committed crime, and yet it does raise concern when a government apparatus is putting on trial a large number of individuals who have served in the previous government. My two questions are, first, with relation to timings. There have been some allegations that the timing for bringing some of the prosecutions or for taking investigative measures such as detaining individuals were coincided with different election cycles, either with the municipal elections in the one case involving Ugulava or with the presidential election case involving Maberashvili. Secondly, the nature of the allegations. Some of the allegations have been very specific, as you have mentioned, but some have been quite open-ended, such as abuse of authority, neglect of official duty, even in one case, inefficient use of budget funds. These are very open-ended charges, and it could explain why they are raising concern in certain circles. And finally, has the state party considered in this regard to address not only the problem of actual independence and impartiality, but the problem of perceived independence and impartiality that these cases raise, and may affect the degree of trust that is in which the justice system in Georgia is regarded. Already in the report, in paragraph 124, you mention a relatively low degree of trust in the judiciary. And are you thinking about special ways to ensure the insulation of the legal system from political pressures, for instance, appointing special prosecutors and the like? Thank you.
Thank you very much, Mr. Shani. And what I propose is, and the next stage is for the distinguished head of delegation, the Minister of Justice, to sum up. If she wants to use a bit of her time to respond to Mr. Shani's question, that's fine, by all means. You want to give that to a colleague? Okay, go ahead.
Very shortly, Ms. Tina Khidashvili.
Yes, very briefly, and we can provide much more information within the 48 hours that we have. Timing, you've said. The charges against Mr. Ugulava have been presented over the year several times on different charges against him. The only reason why he was arrested now, as opposed to any other time, yes, before the local elections, is that now he was planning to leave the country. He planned to leave the country, and he was detained at the airport. So it was his plan, not the government's plan. We are the government intervened because allegedly he was avoiding the justice. That was the verdict from the prosecutors and later by the judge. Nature of the allegations, yes, some of the charges are open-ended because the investigations are not finished yet. But on those charges where investigations are over, you have quite a substantiated evidence presented to the courts. All of those officials, all of those cases against those officials are still under the investigation on numerous cases. So it's not just those that are already in court. Perceived independence and impartiality, I agree that's the problem that we are facing, but Minister of Justice already talked about it and I'm not going to repeat it. How many steps the government took in order to ensure the independence of judiciary and depolitization of the entire justice system. There is a third wave, as it was mentioned already, planned. It's before the Venice Commission, and in the fall there will be another legislative package passed by the Parliament for creating even more guarantees and even more immunity and independence for the justice system entirely, not just the judges, but the entire justice system. Again, we'll be happy to provide further any information about any case, any charges, any evidence, any testimonials that the prosecution has collected against those individuals. Crimes were committed. We are not proud that so many high officials of the previous government are under the investigation. No government will be proud of it, but it will be even worse if we just close our eyes towards that, because for any other government in power in the future, that will be a green card that it's okay, you are immune from committing the crimes. Thank you.
Thank you very much. Okay, that's the conclusion of the exchange. I now hand the floor back to the distinguished Minister of Justice to present her concluding remarks. You have the floor, ma'am.
I would first of all thank you, Mr. Chairman, and thank all the members of the committee. For us, it's great honor to have been able during those 2 days to give different clarifications, arguments, presentations. We are ready, of course, according to what I was able to write down, and each member of my delegation, to give you in 2 days time limit extra information which we were not able to give you during these days. And let me assure you that the fact of being here present with this kind of broad-based delegation from Georgia is the clear sign that the human being is in the center of each of our reforms. Human rights are in the center of our reforms, which was not, unfortunately, the case under the previous different governments. And human rights are, as you are the best place to know, a wide field of work. And we are determined to continue to work in that field. And you should be quite enthusiastic that your reports will get better and better with Georgia, because as the Minister of Corrections, the current Minister of Corrections is a former Ombudsman of Georgia. Myself, I was not born as a Minister of Justice, but I worked during all my life as a lawyer at the European Court of Human Rights for many years. And my colleagues from Parliament are former human rights defenders and representatives of the civil society. So we know what we are speaking about, and we are doing everything to correct, first of all, the wrongs of the past, but mostly to look forward and to be in charge of a better future for our new generations in terms of human rights, good elections, free and fair elections, free judiciary, and many, many other things of which we were able to discuss with you many of the aspects. Thank you very much for your attention, for your understanding, and for the attention you are paying to Georgia and to its future and to its democratic future. What's the most important? Thank you very much.
Thank you very much, Minister Tzouloukiani. I made a remark earlier about a specific response to a specific question or group of questions. I'm going to extrapolate from that. Rome wasn't built in a day, but clearly under this Minister of Justice, a lot has happened in 2 years, and so many of our questions have been answered well and effectively. Of course, there's work to be done, and the delegation has been the first to acknowledge it, balancing problems of impartiality with avoidance of impunity. Something that came up a moment ago is obviously a challenge, but a challenge that the state party is aware of. The need to ensure equality of arms, not just in courts, but especially administrative courts, but also out of court in terms of different religious communities, for example, in the state party. The need to ensure that there are no repetitions of the very serious ill treatment problems that have taken place, not just in ordinary criminal matters, but also in terms of responses to political dissent and manifestations of political dissent. Very, very serious issues that have to be put right, including both through putting an end to impunity and ensuring that an appropriate root and branch examination of the institutions that committed those crimes, those human rights crimes, will ensure that there's no recurrence. So all of it's an ongoing project, but I have to say that, and it's obvious, I'm not hiding it, that I've really come away from an exchange with the delegation more optimistic about the commitment to ensuring the fullest and most effective application of our covenant than I have on this particular occasion. So I won't take up any more time of the interpreters with that. I'm going to give the Secretariat the floor in a moment to make an announcement. I just want to make an announcement to colleagues of a procedural nature, and that is for those that weren't part of the working group on communications, and of course we're discussing communications this afternoon in closed session. I plan to use the same approach that was taken in the working group in terms of presentations of the case, limitations of presentations of the case. So it will be assumed that all colleagues have fully read the cases that we're considering. And it's going to be as many as possible of folder 1, because we only have a limited amount of time to discuss a substantial number of cases. So, Kate, announcement.
Thank you, Mr. Chairperson. Just to remind the committee members that at 2 o'clock you have a meeting with the chairperson of the Permanent Forum on Indigenous Issues, and that will take place in room RS 181. So room RS 181 at 2 o'clock. Thank you.
Thank you, Kate. The session is suspended.